yesterday and we're still like kind of taking out. We don't have a lot of talking points this month, but if you have questions, obviously. While we were sitting in the hotel room, what happened is we took our laptops, because for two of us to be out of the office at the same time for a week, that's why we have to ever go on vacation. That's just really tough. So every morning we check our email and we answer phone calls. So I'm sitting there doing my email in the hotel room today, and I hear him on the phone with a realtor, and I his head is going to spin around the room because they have to tell the story. And I was like, oh my God, this is going to be a talking point next week.
Okay. I just,
I'm just seeing how help yourself, honey.
goes under agreement. P&S gets signed. Buyer is supposed to be wiring in the second deposit. For Friday. The realtor, the listing agent, allows the buyer into the house on Saturday, day after P&S is signed. The contractor
For access.
to have to access the house till it's and they decide, for reasons that are important, they don't want to buy the house. So I say to the realtor, because she wants to keep the whole deposit, which she would be, which we would technically be entitled to. So I say, did you receive the second deposit? And again, this is Monday now, okay? And this is how I knew we had another talking point. She said, I'll have to check with my office, which translates into no. So the lawyer, because how do you find this out? The lawyer at 9 o'clock Boston time calls me and leaves me a message telling me that that's how I find out that the deal's off. I call him back, he's in a meeting, he calls me back, he tells me.
And he's sheepish.
Yeah, somebody I know. He says to me, I said, did your client make the second deposit? Well, like I was born yesterday. They tried to make it on Friday, but the wire didn't go through, so no. So, but they know they have to give up their initial deposit.
Which was $5,000.
It's $1 million house. So I speak to the realtor and I say, well, we should be able to keep the whole 50,000, you know, and plus the 5. I said, would you have the second 50,000? No, we didn't get it. I said, no, you didn't get it. How do you think you're going to go and get it? You're going to sue them to give you a deposit for a deal that they're not going through. I said, if you're going to let somebody go into the house, which is which they're entitled to, at least make sure you have all their money, so that we have a much better case if I'm holding $55,000 instead of 5. Agent is, keep it all instead of having to chase them for all. I said, so now your deal's dead, and you got your client $5,000 because I didn't say this, but because you didn't let them into the house before you had the money. So that now you can tell them that's the end.
Well, yeah, but there's a lot of layers to this that you have to think about. The first thing is, until you have the second deposit in your control, until you receive the second deposit, the seller shouldn't even be counter-signing the purchase and sale agreement. And even if they do, it shouldn't be released because you don't have a binding contract until the terms are met and the full deposit is on. So she kind of dropped the ball in a few areas. Number one, she didn't make sure she had the second deposit before she let the purchase and sale get distributed to everybody. And which made her clients think they have her clients, sellers, let people into their house because they figured they have a binding contract and their realtor's holding $55,000. So who's going to walk away from that? Not many people. But she didn't do her due diligence to make sure that it was in the office, and she let it go. And then, to add insult to injury, she allows an access visit knowing they're coming in with contracts, because I think this was a builder or something, right? I think it was.
It was a contract, I don't.
Yeah, whatever, but they were coming in, so, the lawyer says to Mitchell, as I said, sheepishly, well, you can have the initial deposit, like he's doing us a favor, because he knows we could sue them. But we're never going to tell, I'm never gonna tell, he's never gonna tell the seller to sue someone in this situation. Because in the end, would you win? Probably, but it could take years, and
Yeah.
meanwhile, your
And
house
and
is.
to lead up a lot of the $50,000 legal.
So what's the point exactly? So so the moral of the story is never allow an access visit. I don't care if they tell you they're having an info only inspection. To me, that's the biggest crock ever. An info only inspection is only good if you have all the money in the bank and then you allow it. Because if they try to walk away at that point, yeah, they're gonna lose their deposit. Now, every purchase and sale agreement has language that says that a deposit will not be released until the closing is consummated or by written mutual agreement by the parties, or in the event of a disagreement as to where it goes. Because let's face it, very few buyers are just gonna sign a lease if they want to try to get their money back. They'll threaten to go to court. But if you go to court and you have a proper purchase and sale agreement, you're going to win. It may take time, but you will know you're
You're not
standing
gonna do
on
that
solid ground.
over $1,000.
Right.
Or you're not gonna do that over $5,000.
Yeah, at some point you have to make a business decision.
Right.
Um,
Now, see, in the old days, for most of you, we didn't have electronic signatures. So before electronic signatures, the clients would have to actually meet with the realtors, and that's when the money could get exchanged. Now with electric signing, e-signing, nobody ever sees anybody, and it's become acceptable to say, oh, just overnight us the check, or just wire us the check, or fill in the blanks, send the check. And what happens is, there's a gap between, we get pushed a lot by realtors to hurry up and get things signed because they're afraid people are going to change their mind. Well, you're now giving the people an opportunity to change their mind if there's a gap between when the P&S gets signed and the money shows up. Now, the buyers have a couple days to get their cold feet really cold.
There's nothing wrong with someone overnighting a check or wiring, but they have to understand it's due on the day the purchase and sale agreement is due, not the next day or 2 days later.
Right, so when we're doing these things at night, which seems, people go to 5 o'clock and they decide they're ready to sign now, well, the check can't get overnighted and can't get wired because it's too late in the business day. So I gotta wait another day. And I mean, so it's not gonna come for 2 days. 2 days is a century in what you have nervous people.
The thing is that you can always hold on to the sign, fully executed, P&S until you have the check in hand, right?
Well, yeah, but when you do this, let's say DocuSign, so let's say you're DocuSigning the document.
Right.
If you let your clients hit the button.
Right.
Does the other realtor have access to the DocuSign? No, only if you give them access.
Yeah, I think so.
Yeah.
Okay,
Yeah,
so as
yeah,
long as you can,
You have to send it to them.
withhold
Yeah.
that, I don't care when they physically countersign it, as long as you don't release
It's
it.
about the money now.
Right,
Yeah.
until you have the money.
And see,
Right.
what happens is in our present tense is we'll send it out for signature and the seller will say, then I'll get transaction coordinator, say, congratulations, everybody, and announce it to the world that everybody
Right.
signed everything. Well, that's not necessarily true,
Right.
because as Justine just said, you don't want to release it until you have the money.
And I find a lot of buyer agents so lackadaisy about.
So it's very late, people have gotten very
Getting the-
late.
I want to get the check from my client if I can the day before.
Yeah,
So I
you
have
it in, have it
I'm
in.
in control of it.
Absolutely.
And if
So
I have
good
to drive,
practice.
I will drive.
Yeah.
But a lot of agents just don't care. They're too lazy. I'll get it to you.
I'm definitely.
And the
noticing
wiring
lax.
is, the
People are
wiring
very
is the
lax.
worst.
And the seller is confirming that they have the money when they sign.
What do you think about the deposit link? I finally used it this time and it was like, it's actually
What is it?
pretty good.
What is it?
Deposit link.
I don't know what that is.
Oh, I know that.
So basically, we send a link to the buyer agent and for them to forward to their buyers. And they make a deposit for their
It
first
shows up, right.
first or
Is it like a
second.
bedroll kind of?
I don't know. But
Well,
it goes
it's like an
directly,
ACH, but very secure.
right, it goes directly
You
to
have
the
to open a
escrow
link
account.
specifically for that particular buyer.
And your office accepts deposits
Yeah,
that
they-
way?
yes.
Okay.
And it's super convenient.
Good.
I just want.
But you know, some just, with all due respect, I wish things were a little less convenient.
Okay.
That's what's become the problem.
Oh.
Everybody's
People think they
doing
can get away with
everything
anything.
that's convenient, and it's not necessarily good. It
Right.
just saves you all from having to get into your cars, which is great, I appreciate that, I understand that better than anybody. But if it's gonna kill your deal, which it just killed that one, it ain't worth the
But
convenience.
you know, the best part about this, like, I'm sitting there in the hotel room, doing my email, listening to him on the phone with the realtor. She had her on speakerphone, so I could hear her. And she was like, so shocked that we couldn't just somehow wave this magic wand and grab the deposit. And she kept saying, well, I don't understand, why don't we just sue them? I'm like, think about what you just said. There's no such thing as just suing somebody.
Well, first of all, it's not you that's doing the suing.
And
either.
let me know, the only one that's gonna make out that is us, okay? We don't need to make money on people getting sued. We have enough money with people not getting sued, okay? So that's not something that I'm going to recommend to my clients that you should walk
see,
down to our
well, the
litigation.
problem was that
department.
she figured out she screwed up.
Yeah, she was
So
bad.
she was chasing
So
her,
she didn't wanna have
she was
to-
trying to chase her tail now, figure out how can she make this right, because she's gonna have to make the phone call. Well, of course, I made the phone call.
Well, no, he said to her, I'll call the client now and explain it to her. And I'm sure she was having a stroke thinking he was gonna throw her off the bus, which I heard the conversation. Of course, he didn't. We would never, ever, no matter what we think, ever throw a real bus. That's cutting our nose just right our face. But I could tell, he was like, he was very, just explained to him, sorry, in the scheme of things, we don't recommend that you could, we don't recommend that you sue someone. We recommend you take the $5,000 for your aggravation, which they are, offering up. They're not gonna argue about the 5,000 initial deposit. Take it, you had backup interest, grab one of the other people while they're still interested and call it a day.
Well, see, this was lucky because it was people that were selling a family home, so it wasn't something that there was a rush. But that doesn't always, it isn't always like that, as you well know.
Did you have backup offers?
They
So,
did,
yes,
thank goodness. I mean, I don't know if they were the same caliber.
I have no idea. But it could have had a much more unhappy.
Oh, yeah, oh, definitely.
Yes,
So is the bottom line of this that you don't complete signing a PNS until all the money is in place?
Ideally,
From the seller's perspective,
Okay,
yes,
so you
or you
don't,
don't, if you're the listing agent, you can get them to sign it, don't release it.
just from the list.
when you say don't release it, what do you mean?
I mean, if it's electronically signed, you have control of the document until you release it to the buyer.
Anyway, it's signed, anyway, it's signed.
Okay, okay.
So as
Don't
long
give
as,
it to the
so
listing.
the buyer
to the buyer
signs
agent.
first, seller signs second. If you don't have the money in your hands, you do not release that seller sign.
Because it's not complete.
It's
because
not.
Everything hasn't been.
But all the ducks are not in a row until the money shows up.
So when the buyer's agent calls you and says, oh, I need to get that back, because the lender's looking for it,
That's
you
right.
say, wait, show me the
Where's
money.
money? Right.
Sorry, we're going.
I mean, I learned, in the past, I'm always really fast in doing things. And these days, I learned to hold on, wait and see, because a lot of things will resolve by itself, number one.
By time,
And right, exactly. Number two is that you don't want to accidentally send out something you will regret
correct,
later on.
you're absolutely right.
So it's like, wow, I think you gain that by having years of practice. I think in the beginning, we just thought that, oh yeah, we need to do it fast.
Right, because I am so sure, every time I get a deal, I'm gonna hear from somebody, is it ready to be signed? I get an email this morning from a transaction coordinator for deals not supposed to be signed till tomorrow. Is it gonna be ready to be signed tomorrow? Tomorrow's 100 years from now, in what I'm doing. This was at 9 o'clock this morning, like somebody was waiting for 9 o'clock to send out the email.
We are like that, I'm sorry.
Yeah. No, you and I talk at night.
Right.
But slow down. I mean, there are some things that you don't screw around with, and there are some things that are less important. This part is important.
But you know, it seems that always on the day the PNS is due, the buyer starts signing at 5 and then I have to do it at 6. And why does it have to be us?
Well, don't forget, it wasn't too long ago, before the last year and a half or so, when this market got so nuts, that when we would get an offer from you guys, the offer would say that the purchase and sale date was due in like 7 to 10 days. So there
Exactly.
was all kinds of time to polish it up and get it to plenty of time and all that. Now we're getting maybe 2, 3
Remember,
days.
with home
So it's
inspections
like
being
beat the
waived,
clock.
there's nothing to wait for.
Right, so it's like beat the clock for us all the time.
Right.
Because, when you're the seller's attorney, we draft it, we get it out the door ASAP, but we have to wait for them to make changes, then we have to go over them with the client, and we have to finish it up with the other side and polish it, send it out as a PDF. That doesn't happen like with the blink of an eye, it takes some time. And when we're only getting 2 or 3 days to do it, you're going to always have that
I
situation.
mean, there's nothing less pleasant for me, I can't speak for me, than having to call a client in the morning or middle morning or late morning of the day and say, can you look at this right now? Because it's due today. And
They're
they're
at work.
and their work, and this is the big stuff, and it's a lot of money, and that's a really unreasonable. So then I say, then they say, well, I can't, okay, I'll ask for extension, and I'll call my realtor, and my realtor said, what are you extending for? What do you have to extend for? What do you-"
Because we
Okay.
didn't get these
The
time.
client is entitled to put her time into reading this and asking the questions. So if that means we have to extend the day, you'll have to keep your fingers and toes crossed overnight. At Sunday, and it doesn't really change the room. Well, the house doesn't burn down.
I mean, when we were gone last week, my partner Cindy from Sherman was filling in for me on a transaction for Lexington property. And the clients were like, hey, buying a very expensive house, they were very, detail oriented, nervous folks. And she finished up the purchase and sale on time, it was due on Friday, and she sent it out, with PDF to be signed, it had been some back and forth. And they had extended the signing, because of various and sundry reasons with inspection negotiations. So it was supposed to be signed on Friday. She sent it out plenty of time. She starts getting texts at like 10 o'clock at night from the realtor and the client wanting change. And so she actually picked up the phone and called the guy. And she says to me, I was talking to your client like 10:30 on Saturday night, and he's telling me that he spoke to the loan officer who said, well, now that you delayed the signing of the purchase and sale agreement, I can't meet that financing deadline anymore. So I need you to add a week to it. So he wanted her to add a week to it. She's like, I can't add a week on a Saturday night at 10:30 because number one, it's not something I can do unilaterally. I need the attorney's blessing and I can't get them. And the client was aggravated with her that she didn't somehow magically have access to fix this for him at 10:30 on a Saturday night. People are getting crazy. I mean, just they have no like common sense. It's like gone right out the window.
Common sense, is the least
Go
common
on.
of all sense.
Yes.
Well, that's
But like what you
fine.
just said, Justine, you just talked about rushing and making mistakes.
Oh, yeah.
And we talked about this last month. How many offers we've seen lately because everybody's rushing, where they don't either adequately describe the property, there's missing dates, there's, the math is wrong. Like it'll say $1,000 initial deposit plus 5% when they need 5% minus $1,000. Just do the math, write the numbers in, don't have someone try to figure it out for you. And we sit there, we look at this, someone's spending $1 million for a house and they can't even do the math on their deposit to make sure they get the right money. Like, it's mind boggling.
Well, I think too, because they feel like there's so many offers, gonna be,
Yeah.
Right.
they have to get it in there quickly, you know what I mean?
We get the difficulty that you guys have on the buyer side.
Right.
But that doesn't excuse doing it right.
It doesn't.
That's
It
take
takes
long
2
doing it,
seconds
right?
to
But I'm
review
saying,
it
but
before you
that's-
sign it.
remember, you guys are getting a decent chunk of change on some of these deals.
Oh, yeah.
And it's not an unreasonable expectation
That they're right.
that they're right.
Right, like, for example, the one that Bill was, well, that's past month, but, the escrow holding agency is wrong
Right.
agency, and that just funny. You know that they are in a rush, they just want
Yeah.
to keep
Well, the money
bidding
goes to the
up
wrong
higher and
place.
higher, but they forgot that there's something that's quite important too.
Well, or they're like, people will they'll give us repair lists. And they'll say, and we'll put them in the right format with the signatures so that they can sign them. And then later on, it'll come out
So-
after they've signed it. Oh, that repair list had a mistake on it.
Sure.
How would we know? We didn't compile it. We've never been to the house. We presume before you sign something like this, you're reviewing it. And you're gonna tell your realtor if something has to change, because we paper the thing. We don't compile the thing. You know, we'd have to have a crystal ball to know that there was a mistake on it. But it's like stuff like this happens over and over and over again. It's really a little strange. All right, we're gonna move off that. I knew we'd spend a long time on that, 'cause that one was just like. All right, so orders of conditions. Okay, now where I am in Lexington, a lot of conservation, a lot of places have orders of conditions on it. So when we see those on the title, we know we need a certificate of compliance. And one has been recorded. However, not all orders of conditions are created equal. Some are very straightforward, you read it, it makes sense, and there's something that had to be done as, you know, a condition of the town, that it was met or it wasn't met, certificates issued, end of story. Then there are others which are ongoing conditions, like how far you can, you know, mow the lawn into the area, buffer area, and if you do, you know, if you go over it, the town can find you, so you make, you know, that kind of thing. I always invite my buyer clients who are buying in conservation land, that if there's any question about it, if when they read that document, there's any question, they should call the Conservation Commission and ask and get all of their questions answered before they buy a house. Because I have had limited instances where folks will call me a year down the road and say, I had no idea that my deck was so close to the buffer zone. And I can't put a this, that, or the other thing in the yard. Well, again, I wouldn't know. I've never been to your house. So that's why there's some things that we can do and we know to look for, but we would never even anticipate being able to tell you about that. And also, it's like, not all closing attorneys, let me just make this point, not all closing attorneys are created equal. If we see an order of conditions on a property, so let's just say I'm just the bank attorney or the buyer bank attorney, and I didn't know about it, comes back on the title, it's an order of conditions. I'm gonna make sure there's a certificate of compliance. Do you know how many closing attorneys won't even tell anybody? They'll just schedule it on the title, subject to order of conditions. I won't even call or even point it out to anybody. So that's what I'm saying, is that there are idioms, there are things, there are levels of different things that buyers don't even know that they don't know to ask them, which is why you always want your buyer clients to have a personal attorney. No matter where they want to cut corners, that's not the place to cut it.
Well, this is the same story as permits. Justine, tell the story about a buyer's agent who doesn't do the homework, the necessary homework.
Am I
And,
the buyer agent?
no, you're the.
No, because I was the buyer agent for that property.
No, but
and then
you
turned
did, you did
seller
fine. She's listing agent, she's some, yes, we handled it years ago when we bought,
agent. Right.
and now we're selling. She does everything fine. We have the usual P&S that says, we disclosed, owners disclosed. We didn't have any work done during the time we owned the house, and it requires a permit, usual stuff. Okay, we signed the P&S.
Yeah.
So we're done, okay, all the due diligence should have been done.
And the financing contingency was waived, so it's a done deal.
Right.
And suddenly,
Okay, so then, Justine, what happens? Because you get contacted first.
so suddenly.
Well, she's got a realtor on the other side, we're doing this 10 minutes, right? We decided that the buyer's agent was a rookie.
I don't know.
Or
if-
just-
rookies.
Yeah. No, nothing wrong with
No,
rookies.
but when you're a rookie, you have to know to ask questions. That's all.
So I had buyer actually call me, texted me directly.
Okay, that's
several
wrong,
times.
that's wrong in 1,000
Right,
letters. Anyway.
that's so wrong, because they know that I'm going to always say the good thing about the house. I mean, honestly, there's nothing to hide in the house. There's, you know, the seller pool, well, so back to what's going on was that suddenly I got an email that from the buyer's attorney, say that just.
Again, totally wrong.
Yeah.
She's getting an email from the lawyer. I'm not getting an email from the lawyer. She's getting an email from the lawyer.
Right, got an email
So you're
from
rookie
the,
too?
No, actually, I work with the attorney, that's why he can just,
He's
you know,
more
very
comfortable.
direct with me and, you know, I appreciate
You
that.
work with another attorney?
Yeah.
Trying to-
We have that conversation before, so. So what happened is that they said that there are 2 open permits. And I was starting to, you know,
Yeah.
like shaking because that's like, you know, Mitchell was talking about that
Yeah,
last time and this happened to me. So I immediately went up online and go, you know, take a look at them. And turned out, well, it's just because that it wasn't closed. It's not a super big deal. However, and what I was grateful for is that people are still in the field doing the work, even though they change companies. So you can have that person, that contractor to close that permit. And then the other one was a lot easier. The point is that, you know, I assume that once we get the CO, all the permits will be closed. That is a wrong assumption. So that was my part that.
There's new construction?
No, it was new construction when we bought.
Right, when we bought, it was a inside a gut job, right? So that's why we got the CO. And
I would have thought the same thing you thought.
exactly.
No, we're all wrong.
And we were all
What
wrong.
town was this?
This is
Lexington.
In Lexington?
Yes. One I would say it was the seller pulled permit to install gas
So
dryer.
that one has,
And,
Oh, post purchase.
that's one, but the other
post-purchase.
one was developer.
right, it was developer. So
That I would-
because of that, you know, that's just something that we always have
But
to
here's
be
what you have to be
careful.
really careful of. So you represent the seller, right? Okay, and a buyer's attorney, because a lot of buyer's attorneys, you know, just kind of cut paste from other attorneys, writers. So you see some of the same stuff over and over that's exactly verbatim from one you saw before, because everybody steals each other's work. And there's one that's really out there all the time, where buyer's attorneys will say, and we have our own kind of format, they'll say to the best of the seller's knowledge, or it won't even say that, so the seller has done no work to the property during ownership prior to permit, and in the event we find any open permits, seller has to close them up prior to closing.
Right.
When I represent a seller and a buyer's attorney sends that to me, I cross out 2/3 of that provision. I change it to say, to the best of seller's knowledge, without independent inquiry, we don't have any open permits. I never allow it to say that we will close them out,
Right,
because I
that's
want to
fine.
know, during the purchase and sale stage, go do your due diligence.
That
Go
should
look
happen
into it.
regardless. The
Go look
buyer,
into it.
the buyer's side.
Right, the buyers, if that's important to the buyer,
how do you find out if they're open?
just call the building inspector's office. Some towns are better than others, you can go online and see it. Sometimes you have to call, they pull the building jacket, they'll tell you.
Or you could
It's town
actually
to
go in.
town.
So,
Yeah, but these,
You can
boy,
go into
like not a
town
lot of
hall.
town halls will let you even in, but still with the code.
Who's responsible to get that information?
The buyer and their agent.
buyer
The
agent.
buyer's agent and the buyer should together, if it's important to them, they should look into that. Because if I'm a seller's attorney, when they give that to me, I cross it out, and I put a little comment in the margin and I say, did you find any? Because if you found them, tell me now, I'll go to my client and we'll find out if they can handle closing it out, or if it was something that happened. If it happened 20 years ago, who cares? Because
Right.
towns don't, after 10 years, towns don't care. But if my client did it 2 years ago, they can call me a contractor.
But what we're talking about is buyers, agents doing things in a timely fashion. Not that, you know, just,
Yeah, we don't, as a seller's agent and a seller's attorney, we don't want to get a call the day before the closing that they just got around to going to town hall and, oops, we found an open permit. We want to know that in the purchase and sales stage. That's why you never let them have that open-ended provision.
That's very hard now because it's a bidding war, right? So the buyer agent wants to nail this property. So they wanted to sign like in 3 days. That's exactly what you were just saying, you know, that you guys didn't get enough time. And that's what happened.
fair, but you're talking about one phone call by the buyer's agent
Or
to
the
the
buyer.
town, or the buyer, to the town. In a couple of days, they have to make one phone call,
The minute the ink is dry on the offer, they countersign it.
one phone call.
So legally, can we just ignore the open permits?
Shouldn't.
We shouldn't, right?
No,
Even
and not all open permits are created equal. If you find an open permit that's 9.5 years old for something that was, readily apparent, let's say they had the roof replaced, and they gave you a copy of the warrant, and you can, and your home inspector or you could tell that there were no leaks or whatever. If it's about to be 10 years or more, you maybe aren't gonna make a big issue of it. If it was a year ago, and they just put in a new bathroom, for example, yeah, you want that perfect closed down.
And how do you go about closing out?
Then the seller has to call the contractors that they use to go and get it taken care of.
Yeah.
That's how you root out, what if somebody uses an unlicensed plumber? Then you
Well,
don't
then
want
they wouldn't be able
necessarily
to get
that
the
house.
What if?
Unless the plumber would be able to get a permit.
And here's the second problem we had with this one. They had work done, there was no permits, ever. So in other words, there's no way to prove a permit, you can't say the permit was not closed out because it was never asked for. That was part of this problem too. And it ended up, long story short, we had a square footage issue too.
Right, we have.
All sorts of stuff that could have been resolved
Right.
before the fact.
Right.
And it ended up, the funniest part of it is the lawyer is giving her, because he works on her, a really hard time. And me by extension, if the value is diminished. And the client, so she goes about trying to set up for the building inspector to come out and all this kind of stuff. The buyer again calls her and says, oh, I hope, don't do anything. Don't do anything.
Right.
We'll
So-
buy it, don't worry about it.
So this is what happened, so sometimes, so what happened is that the buyer attorney understands the issue different from what the buyer wants.
Yeah,
So-
they don't communicate.
Or actually, I think there might be a language
Wow.
barrier.
Yeah.
And so that's why they misunderstand each other. So the important part is just to have all the permits closed. However, the square footage got brought up, so I started to freak out again. I'm easily
Right,
freaking out.
and we both were freaking out.
Right, in the middle of the
In the
night,
middle of the- Not with each other, not with
I was
each
just
other.
gonna say, wait a minute.
No, well, she was getting emails, she emails me 9 o'clock at night, whatever it is,
Oh,
so,
10 o'clock
10 o'clock,
after that,
and
yeah.
I'm staring this into, what are we
So
gonna do, what are we
don't
gonna do? Because, big square footage can be a big issue,
It's a big issue.
and nothing we can do about it until the next morning, but,
So next day, the buyer actually called me directly. And so we had a conversation regarding the square footage and then the permit issue. So I said that permit definitely will be closed.
Right.
The square footage, the good thing about is that if I go to the town and update it, you guys are going to pay a lot more taxes.
right,
Would you like that?
they didn't like that.
They decided, no.
They didn't like that.
Let it go.
And I have, in all due deference to the lawyer, who I will not mention his name, but he works with her, so he's usually on the same side. Well, this time he's not on the same side, he's on the opposite side. And that's really hard.
It's
When the
hard.
realtor that you're doing business, that you do a lot of business with, is on the opposite side, and you have a problem. Because he was dancing around Justine in those emails, it could not have been sweeter, and,
But he's always sweet though.
oh, but I'm just
so-
saying, but I can understand in this
Right.
particular deal, he had to be very deferential,
Right.
because, what was the square footage? What, would-
So the town, the fuel card says that the house only has 17 something, right? But in actuality, after the refurb or remodel, it should be like 24 something.
So they did an
28
addition.
Finish the
The
basement.
remodeling was an addition,
They finished the basement.
finish the basement.
Right, and plus maybe sunroof or whatever. So, so that is a challenge for me when I listed it. I hired someone to do the square footage. What it came out was also different from the original listing agent. So I thought, what do I do?
Well,
What would you
whenever
do?
you're the listing agent, okay, when you're first gonna go see a property for the first time, if they hire you and you're sitting down to sign an agreement, he should be asking this question. Any recent renovations?
Yes,
Okay, how long ago? Well, did you use a license, this, that, or the other thing? Do you have a folder with your paperwork? If not, then you should take a little
We
travel over to
bought
the
it
building
directly
inspector.
from the realtor slash builder. So,
Yeah, I usually, when I prepare a listing or look up a listing, I compare what does public record
Yeah.
have. Does it include finished basement and that, I enlarge the little drawing and double check.
Yeah.
So I
It's
can
a good
ask.
practice.
Well, some photographers also do
Right.
the dimensions for you.
Yeah.
So you can collect all that.
that's what, that's what.
And then I've disclosed on the disclosures, public record shows this, but this is what's measured or
Right.
whatever.
Yeah, well, it's a good practice, just so that no one says you were misleading, right? Because then next thing you know, you'd be.
Because that's kind of what they were hinting with this, they were, that
Because
she
I
had
said,
misled.
yeah, measurement, it's approximate.
If God forbid it should be the other way around,
Right.
what you said it was less than what it actually is, yeah.
Okay, moving on. I've had lately, it seems like a crazy, another common sense problem. I've had people show up at closings and they're trying to rush me because they have a contractor gonna be there in half an hour. And I'm like, no. You cannot go into the house.
Or the moving van
The
is
moving
waiting in
van.
the driveway.
Yes.
That's one of my favorites. They say, excuse me, they make the phone call. No, would you sign the papers now? Who is that? Oh, it's the movers, they're in the driveway.
I mean,
And then
usually,
they were waiting for a wire from their previous sale and all, all that kind of stuff. So it's
It's got
hours
keys.
away. It's hours away from being able to do that.
people will say, can we come in for 8 AM closing? We want to move the house by 10. And we say to them, we can meet you at 8 AM. That's not a problem. Closing will take maybe 45 minutes. But we cannot
Exactly.
record a deed until we have collected funds, because we're a good fund state. So until the lender dumps the money into our account, which typically doesn't happen until like mid-morning.
Especially the bigger national
Yeah.
lenders do their wiring out of funds at one time a day.
Right.
It's not per
It's not gonna
closing.
be there at 8 in the morning when we get in.
Right, and if you're
And-
dealing with a company that's not based in the eastern region, even more.
A lot of lenders, a lot of the bigger lenders, they not only, you don't have the money right away, or it might take a little while, even if the money's in your account, like this morning I had one, and it was guaranteed rate. And the money was already in my account, which is great. However, I had just explained to the people, we can't just record, because guaranteed rate requires that you scan like 25 documents to them, so that a clerk can sit there and check off that they were all signed properly, initialed properly, the numbers are matching. And then you get an email from them saying you are authorized to fund. So even though the money's in our account, we can't send the documents to the registry until we get that. And if it's a busy time of the month, it's a busy day for the particular lender that requires this, and I'm not just picking on guarantee rate, a lot of them do it, okay? Unless it's a small local bank, a lot of the larger ones are requiring, this is a new thing over the last, say, 5 years, that you cannot go to record until you get that magic funding email. And sometimes we'll be waiting until 2 o'clock in the afternoon until we get it. So now you've wasted hours and people are calling you constantly, can I use the keys, can I use the keys? So you need to set expectations with people about not being able to walk out of a closing into the house. That's never, on a rare occasion, going to happen. Unless you're in New Hampshire. In New Hampshire, recording is not as important because you have gap coverage up there. So
You still need the
but you
money.
still need if you're closing with a lender that requires funding authorization, you still have to wait for that. I don't
But
care
you still,
where you
but you
are.
still need the money anyway. So in other words, gap coverage doesn't help you if you're not funding it.
You're not funded or they haven't authorized you to consummate the closing. It doesn't matter if you don't have to get recorded at the registry. That's less important.
But the point is, and one other thing, make it really, keys are not our responsibility.
Right.
Very important. Keys are not, one of the real pet peeves, Erin can speak for herself. And I'll say it just because I say it. Do you have your keys? No. Do you have arrangements to make, and their agent is sitting right there. Do you have arrangements to get the keys? No. Do you know who has the keys? No.
They think we have.
Of course, key everything.
And I say, gee, is there a lockbox or is there a keypad outside the garage? Not, a lot of times.
We've already gone beyond where we should. I mean,
Yeah.
so that's,
But like, we'll say to them, like, if you have the code, just don't go into the house until you get the magic email from Stacy that says, congratulations, the deed's on record.
But so, again, we don't get, yes, if somebody drops them off in our office, then we have the keys. But I'm not asking we're not gonna ask our paralegals to start searching where the keys are. Not a lot of things we have to get you guys to do. Make sure you have the money in the beginning, make sure you give the keys up in the end. That's the two things. that we
And
do.
don't let anybody have an access
Money
visit
keys, money keys.
Yeah.
prematurely.
It's not hard.
No access visits prematurely.
Right.
In the limited instances where your clients, your buyer clients are inheriting tenants, if you can, try to get estoppel certificates. And if you need blank copies, we'd be happy to supply them to you. An estoppel certificate is a very simple one-page form that you just have the current owner have the tenant fill out, where they just put the name of everybody residing there. Sometimes you have somebody who signed a lease, but they have 3 units. Whoever's living in the property, so that you know for notice provisions, how much they paid, so you can confirm that they gave you the correct rent, and if they're holding a security deposit or last month's rent, because you can
And
have
it's
a seller
important to
saying
distinguish between the two.
And it's important because if they've been there for a really long time, you'd be amazed how many sellers don't even remember, because they took that freaking security deposit, put it in their own bank account, and never kept it segregated. Because if you kept it segregated, then you just shut the account down, and whatever the actual interest is, which is pennies, is what gets transferred. If you had somebody living in your house for 10 years and you commingle the money and you never paid interest, more than 5% compounds over 10 years, and somebody has to do the math. It's not fun. But what you don't want to have happen is the closing happen, and then the tenant goes to move out a year later, and now we're getting a phone call. Oh, they're asking for the security deposit. We didn't know they had one. Well, if you'd had a copy of their lease, or if they were tenants in building, you had a estoppel certificate, they're worth their weight in gold if you get them signed. And in the cases where they say, oh no, they're not going to sign it, antennas should go up. Why don't you have a good relationship with them that they won't sign it? Do you want to inherit a problem tenant? Because Massachusetts is not a fun place to have a problem tenant.
I put it in the offer,
Excellent, excellent.
and then the listing agent calls me, what is that? And I said, I can send you one.
That's right, they're very useful, right? Do you guys have any questions for us? Anything happened since we were here last?
All right, when is the have you already had the shareholders meeting?
No,
When
I
is
don't know
it?
if we had one this month.
Yeah. Tomorrow, isn't it?
Next one?
Next Wednesday, next Wednesday.
Oh, no.
That
No.
doesn't make sense.
I think more people should come to the class.
It's funny, it's
I-
prime of reason. Sometimes we
next-
have a dozen
next
people come, we have
Tuesday.
20
I've
people.
been saying that for years.
I'm told, and I suspect the excuse is, and maybe the reality is COVID, and people are just not coming into the office. But we've had this issue of mediocre attendance forever.
Often I'm busy.
A lot.
No, it's one thing, it's one thing, it's fine, you're busy, but there are people that just don't even bother.
If I can,
I mean, how easy can we be when we can't get a conference under agreement? Because, I mean, as buyer agents, you have to fight.
And I agree, and then there are certain times that happens, but the truth of the matter is, the majority of times people say they're busy and they're nice and warm in their house and they want to stay nice and warm in their house.
Which is, I think it would behoove people to come here. Every time.
Oh, I
every
had
time-
to, we
every time I
see the
leave
same
here-
suspects every month, and I give you credit because you're keeping yourselves informed and learning from our.
That's it. Even people that have been
Yeah.
realtors for a long time.
Yeah.
Should be coming here.
Well,
because it's
so we
all-
have two issues, two different groups of people. Interesting point. We have the newer folks, the rookies. You
Nothing
give you
wrong with
credit for
rookies.
coming in,
Nothing wrong,
who
yeah.
don't know what they don't know. Okay, so they don't even know that they should be doing something like this because they don't even get it. Then you have the experienced people who already know it all.
Absolutely.
Right? We know plenty of people that think they know everything about everything. And will tell you that, and they don't come. And then we have a third group of people who use other lawyers than us. That's just the way it is. We're perfectly thrilled for having you. You don't have to not come, because we're the only ones that do this for this office. all the other lawyers you all use, or they all use, are not coming in here. So if you're waiting for that education, you'll be waiting a while.
We don't even need to be, I mean, we always say this. We appreciate folks that use us and are very loyal to us and think of us first.
Yeah.
I also like people to think of me second. Because the person, your first string isn't always available. They might be on the other side.
Justine's
And you need to
right
have
there.
other folks.
The deal
So
that I
I'm
have with
happy to be
Justine right
number
now
two.
is an example. We were second. That's fine.
Hey, no,
We'll take
actually,
it.
the seller, they use you, no, the
I
buyer
did.
use
But,
it.
but the fact is that you even thought of us is great. I mean, I appreciate the fact that she has language barrier issues for her clients. I speak Mandarin, so I get that. But that being said, I appreciate the fact that she thought about us second. Because, we're not gonna be number one for everybody. And you're not always gonna get to use number one.
And under the part about you think you know everything, today I told him on the way in here, just because I was driving, I was thinking of the date, November 16th. 35 years ago today, I started working as baby lawyer out of law school for him.
Wow.
He hired me for the firm that was the precursor to the current firm. So I've been in the same office, the same firm of essentially my whole 35 years. And the reason I'm telling you that is I learn something new every week.
That's right.
Every week, something happens, and I think, I never saw that before. So, and tomorrow night, I'm having my every other month or so, I meet with some other women lawyers that are in my area that I've known for many years. We've become like a little club. And we sit down and kind of like bench with each other, things that have happened. And we bounce ideas off each other. Can you believe this just happened to me? Don't let it happen to you. Like, kind of like what we're doing here. So I'm doing that.
Only this
tomorrow.
wine.
Yeah, only this
Yeah.
one. Yeah. And some of us suck it down much quicker than others. So tomorrow night,
And
that's
it's the
where,
opportunity to
that's
speak
where
ill
we
of
will
other
be.
lawyers, yeah.
We will be. Oh, God, yeah. So it's a
Off the
nice
record, of
bend,
course.
it's a nice benching session with wine.
Nice.
Yeah.
No, because you have issues in your office. You say, am I the only one that has this? You talk to somebody else and everybody has the same stuff. With the same people. All right, thank you guys.
Thanks for
Thank you.
coming.
Thank you. Always learning experience.
Fish.
Yes, Frank.
I sent you.
So are you Amy? Amy, Lori